All right, good morning, everyone. Welcome to the Judicial Proceedings Committee. Today is Friday, March 29th, 2024. We have three voting lists on the docket here. Or four voting lists, rather, on the docket here. We're going to start off, though. So we're going to start off with voting list number 19, but the first bill we're going to tackle is on voting list 20, which is Senate Bill 404. So, Jamie, we'll go ahead and have you read us what we're going to do with that.
Senate Bill 404 requires a law enforcement agency that receives a qualified request. Oh, wait, sorry, I'm reading House Bill 404. Senate Bill 404 establishes reduced penalties for cannabis-related violations of the prohibitions on being a volume dealer and a drug kingpin under the criminal law article. It authorizes specified individuals incarcerated for violations for specified drug offenses to file an application for modification or reduction of mandatory minimum sentences, modifies penalties for crime classifications for specified firearms offenses, and authorizes a person at least age 21 to manufacture personal use amounts of cannabis as specified in the bill. There is an amendment in your voting packet. Should be.
Just to be clear, the amendment is under voting list 19, and it is for Senate Bill 404.
Thank you. Yeah, a little confusing. We actually have Senate Bill 404 and House Bill 404 on today. But the amendment in your voting packet is Amendment 813122/1. That is for Senate Bill 404. What this does is it strikes provisions of the bill and makes an amendment to Section 6411 of the criminal article, which pertains to entering or trespassing on property while possessing a firearm. It amends subsection B of that section, which pertains to exceptions to that prohibition, and would provide that a person who has retired as a law enforcement official in good standing from a law enforcement agency of the United States, the state or another state, or a local unit in the state or another state who possesses a firearm if one, the person is carrying the person's badge or credential in compliance with the requirements of the badge or credential, and the firearm carried or possessed by the person is concealed from view under or within an article of the person's clothing, and the person is authorized to carry a handgun under the laws of the state or the United States. Or two, the person possesses a valid permit to wear, carry, or transport a handgun, and the firearm carried or possessed by the person is concealed from view under or within an article of the person's clothing.
So just real quick, no, we didn't. So it's the amendment strikes the bill, okay, and uses it as a vessel for this other amendment, which is an omission from when we passed SB1 last year. And so this allows for those folks, retired law enforcement officers who are obviously gone through the requisite training and have a valid HQL to do their wear carry in these locations. So, Senator Carter.
At the risk of not being happy, what is the rationale for carving out this specific exception? Anyone that has gone through the training and is licensed to wear and carry ought to be in a similar position. I don't understand what is the reason that we need to make this exception.
So there's a federal law called LEOSA, and the retired law enforcement officers believed that they were covered under LEOSA, which is in part why this wasn't included in last year's bill, that LEOSA granted them this right already. Retired law enforcement officers have a very specific legal structure that allows them to continue carrying their firearms in certain circumstances that other people do not have, even those that are licensed and trained. And so this is consistent with what federal law seeks to do, which is to provide certain limited protections for retired law enforcement officers. I think there was an intention that this was in last year's bill. I think there was an idea that because of LEOSA, we didn't need to specifically put this in last year's bill. When we were made aware that that this clarity would be helpful to our retired law enforcement officers, we came back and that's why it's going in.
Sure. So I have no problem with the law enforcement officer, but on the individual, which is the second half of it, I thought last year that we passed the part of Senate Bill 1 as we finally passed it indicated that you couldn't enter someone's house unless the person gave you permission to carry a gun, but you could go on their property to go up and knock on their door with a gun. So how is this different from that? Am I correct in my recollection of last year? And then how is this different?
Right. So if you turn to, it may actually be easier to look at the page of the amendment instead of the reprint. But if you turn to the last page of the amendment, page 4.4 of the amendment, it provides in subsection D the prohibition. So a person carrying or transporting a firearm may not one, enter or trespass on property unless the owner's agent has posted a clear and conspicuous sign that is permissible to wear, carry, or transport a firearm on the property, or would provide a person wearing, carrying, or transporting a firearm may not enter or trespass on property unless the owner or owner's agent has given the person express permission to wear, carry, or transport a firearm on the property. So a person who willfully violates is subject to those penalties. What the amendment is doing is making that exception for retired law enforcement wouldn't be subject to that prohibition.
Well, what about, again, so I'm looking at B7 subpart 2.
Part 2.
Oh, I see. It's 7. The whole 7 it relates to law enforcement.
Right. It all applies to retired law enforcement.
So is this in D? Is this new language or is this existing law?
That would be existing law.
Well, that's
the that's one, right?
Right.
That's right.
Correct.
So it's still.
so. This is okay. It's just inconsistent. My recollection of Senate Bill 1 is
There
again you can't go in someone's house unless they permit with a gun unless they permit you. Even if you have a carry permit, but you can go on their property. You can knock on their door if they don't.
and as you
without
mentioned that,
permission.
Senator, there is. That's my recollection too. Could I just, I have Lexus up right now and I'm just pulling up the 6411. Not in the trespass section.
Maybe somebody else. It might maybe someplace else in the statute then. What?
I remember it too.
Yeah, I remember that was the distinction we drew. You couldn't, if you're carrying a gun with a carry permit, you can't go into their house unless they specifically permit you to come in their house with a gun. But if you want to go knock on their door, you can walk up their front walkway to knock on their door with the gun, with your carried gun, and that's not against the law. This would appear to make it against the law.
Looking at the prohibition, we do address dwellings, in this section of law. Right, you're right. I skipped over that. So that's the other prohibition. It's all part of the same section. So in C, a person wearing, carrying, or transporting a firearm may not enter or trespass in the dwelling of another unless the owner or owner's agent has given express permission either to the person or the public generally to wear, carry, or transport a firearm. And then D is those circumstances outside of a dwelling.
So the property itself.
So what's the wage requirement?
So I guess. Quiet, big, I just am confused.
This is to help our friends.
I understand,
Defo,
I
yeah.
understand. So I'm in favor of the bill.
I just want to be clear. So everything that's already in there that was passed last year with the underline. This we're doing is the bold underline. That's the new part. And the other part is going to be under appeal or whatever. So it'll be handled in due time. The question.
Supposed to stay according to the Constitution.
Yeah. You're not supposed to have.
Is it my understanding then that, and this was not something that I had originally seen. So everything else in that SB 4 is wiped out. SB 4 is now just this,
404 is
or SB 4,
completely,
I'm sorry.
is
404.
the bill is, I mean,
It's basically adding in what was missed last year on SB 1 about law enforcement.
We're using this as a vehicle.
That's it. Okay, perfect.
Done yet. So we adopt the amendment. Is everyone okay? All right. So, Senator McKay.
Thank you, Mr. Chairman. I'd like to make a motion that we do a summer study out of this, talking about the trainers requirements and different things like that.
To be an instructor.
Correct. Correct.
right. So Senator McKay, feel free to correct me. I guess your motion is to have the committee also summer study the issue of licensing and training for the instructors who teach the HQL courses and the wear carry courses in the state. And I believe it was for the chair to appoint Senator McKay as
That was the other
to
part.
head
That'd be-
that summer.
I would be
study.
interested in being the chair for that. So yes, sir. Make the following motion.
Okay.
There's no language being added to the bill. It's just going on the record that the committee is referring that for summer study. Yeah.
All right, now Senate Bill 404 as amended is before you. So
I think it probably, summer study is good, but what are we gonna do with the other part of the bill that has been stricken? Is there any study on dealing with the penalties for the cannabis that was initially a part of the bill? Okay. Okay, thanks.
motions for favorable with amendments been seconded. Is everyone okay being reported in the affirmative? All right, Senate Bill 404 as amended passes unanimously. We're now going to hop back over to voting list number 19. And Josh, you're up with House Bill 105.
House Bill 105 expands mandatory participation in the ignition interlock program to include any individual who was granted probation before judgment for driving while under the influence of alcohol or under the influence per se, as well as any individual who is convicted of or granted a probation before judgment for driving while impaired by alcohol.
Make a motion that we can form it to my bill. Since my bill does the same thing.
System thing that Delegate Atterbury and my bill are technical cross files. We worked off of Senator Muse's bill. My bill and Senator Muse's bills are now combined. Senator Muse's bill wasn't originally attached to Delegate Atterbury's bill, but we're now taking her bill and
So Senate Bill 118, which is what this would be getting conformed to, authorized a person to file a petition for expungement if the person received a probation before judgment for a charge of violating 21902A or B of the transportation article, which is DUI or DWI for alcohol. The petition may not be filed within 15 years after the date the petitioner was discharged from probation. The bill also required participation in the ignition interlock system program if an individual was convicted or granted probation before judgment for 902A or B offenses, so those alcohol offenses, and it made corresponding technical changes.
Motion's been made, it's been seconded. Now the bill's before you as amended. Motions for favorable, seconded. Is everyone okay being recorded in the affirmative? Okay. House Bill 105 passes with amendment. Now we're gonna go on to House Bill 338.
House Bill 338 establishes requirements, procedures, and prohibitions to govern the use of facial recognition technology by law enforcement agencies. This is the cross-file of Senate Bill 182. There are a couple of differences between the two versions of the bill. So the House passed a version of the bill which included a provision providing that the bill preempts any local restrictions on the use of facial recognition technology. And the Senate bill included some language adding to the report required by the bill for each law enforcement to file annually on their use of facial recognition to include information on the age, race, and gender of individuals. I'm not sure if it's in your packet, but on that point, I think there was a compromise amendment. I can read the language if it's not in the packet. Oh, it's there. I think the distinction between this version of the amendment and what the Senate initially passed was the Senate version initially required information on the age, race, and gender of everyone who was subject to a facial recognition search, which I think there was some concern that that was much too broad. So the way that the compromise amendment was drafted is it specifies that it's only those individuals on whom a possible match was returned by the facial recognition search. Yes, exactly.
So Delegate Moon and I we have to have a conversation about the whole preemption piece, because that's something that was not a part of the original bill. And I understand some of the Office of Public Defenders, there must have been some misunderstanding when it was introduced, because they are opposed to the language as as it was. So he and I talked last night, and I would like at least to hold it until Monday if possible and try to see if we can figure something out about the whole preemption.
Like state.
I think local governments, this would be a ceiling to what they could do. So, and there's an issue with that.
All right.
All right. Thank you.
Senator asked for a hold. We'll hold it. So House Bill 338 is going to be held until our next voting session. All right, we'll now move on to, I think it's Jamie, House Bill 404.
So this is House Bill 404. House Bill 404 requires a law enforcement agency that receives a qualified request for a wellness check of an individual to immediately conduct a wellness check of the individual if the individual is located in that agency's jurisdiction, or submit a request to a relevant law enforcement agency in the state or another state to conduct a wellness check if the individual is not located in the agency's jurisdiction. A law enforcement agency that receives a qualified request must meet these requirements regardless of where the individual or entity making the qualified request is located. There are no amendments in your voting packet, but I would note that the bill is a cross file to Senate Bill 190, which passed the Senate 45-0. Senate Bill 190 approached the issue a little bit differently than what the House did. It required a law enforcement agency that received a request to conduct it within a reasonable amount of time after receiving the request for people within the agency's jurisdiction. For people that were not within the agency's jurisdiction, they were required to promptly provide the person who made the request with contact information for the agency that does have jurisdiction. Also, the Senate bill provided that a law enforcement agency was not required to conduct a wellness check under three circumstances. First, if the agency reasonably believed that the individual was not in physical danger and is not physically injured, or unless the law enforcement agency believed that there was physical danger or physical injury, the law enforcement agency reasonably believed that conducting a wellness check would bother, harass, intimidate, or torment the individual, or that the individual had requested that the law enforcement agency not conduct wellness checks on them in response to these types of requests. There were also two exemptions for civil liability under the Senate bill. Specifically, the Senate bill provided that nothing in the bill may be construed to create a cause of action against a law enforcement agency, its employees, or its agents for a failure to conduct a wellness check in accordance with the bill's requirements, and that a failure of a law enforcement agency to comply with the bill's requirements may not be used as evidence of negligence or recklessness in a civil suit against the agency, its employees, or its agents.
But Senator McKay.
So my question is, when we're talking about law enforcement agencies and that kind of stuff, I think 404 on the House side, they were putting EMS.
That is correct as well. There's a corresponding
I was going to say,
requirement.
we need to take out the EMS firefighter part. They're not qualified to be going into homes for a wellness check. Somebody may be mental health issues. I believe law enforcement's more trained for those type of things, especially out my way with volunteers. I mean, literally it's volunteers. So it's like the local dry cleaner just got on the truck.
Yeah.
And now you're going to have him go do wellness checks. I don't know. So I'd rather conform to the Senate where we don't have the fire EMS. So.
All right, so motions to conform to what we did in the Senate. Is everyone okay with that? All right, now the bill's before you as amended. Motions were favorable with amendment. Seconded, everyone's okay, we've been recorded affirmative. House Bill 404 passes with amendment. All right, we now move on to House Bill 458.
House Bill 458 prohibits the court or a party in a criminal or juvenile delinquency case On notice that an electronic or paper filing includes identifying information of a minor victim, from disclosing or allowing inspection of any such filing, including a charging document, to a non-party unless the court or the party disclosing or allowing inspection redacts all identifying information within the filing, or the court finds by clear and convincing evidence that there is good cause to order otherwise. Identifying information means the name of and any other information that could reasonably be expected to identify a minor victim. This is the cross-file to Senate Bill 111, which the Senate passed 46-0. The difference between the two bills is that the Senate bill did not include language that the prohibition applies on notice that the filing includes identifying information of a minor victim. So just the key distinction there is that the triggering language is that if the court or a party has noticed that there's identifying information, then the law applies.
And just to make certain, the language you were just talking about, that's at line 14 on page 2. That's the court's language that we were. Okay. So the thought was that we take that language that I thought the House had on it, but I'm looking at my bill. I don't see it in my folder, but it should be conforming to whatever the House was. The language that Jamie spoke of, if it's at that line 14, that's what we wanted. That was a court amendment.
So
is it not in there?
Well, we don't have the Senate version. So are you talking about an amendment for the Senate bill?
Yeah, yeah.
Sure, that would be over in the House.
We just do straight favorable if you want to keep it.
Right. If you want the on notice language, then you would motion for a favorable on the House bill.
Okay, got it.
So all right, there's been a motion for a favorable. It's been seconded. Is everyone okay with being recording the affirmative? House Bill 458 passes unanimously. All right, we'll now go on to House Bill 508.
House Bill 508 alters in statutory provisions that govern child in need of assistance proceedings and the reporting and investigation of suspected child abuse and neglect, the definition of abuse to include labor trafficking of a child by any individual. The bill also expands statutory provisions related to the Safe Harbor Regional Navigator Grant Program to apply to child victims of labor trafficking. The Senate bill is substantively identical and passed unanimously from the House. The House is going to add a technical amendment, so the motion on this would be for favorable.
Move favorable.
All right. I'll second, but further discussion? Is everyone okay being recording the affirmative? All right, House Bill 508 passes unanimously. We'll now move on to House Bill 597.
House Bill 597 is an administration bill that renames the Law Enforcement Cadet Apprenticeship Program in the Maryland Department of Labor to be the Public Safety Apprenticeship Program, and expands the purpose and scope of the program, including expanding eligibility for the program to include public safety agencies instead of just law enforcement agencies. The bill is virtually identical to Senate Bill 470, which passed the Senate 45-0. The Senate bill and this bill, in fact, are identical in every way except that the work group on growing engagement in the law enforcement and corrections workforce is named differently. The Senate bill reads the corrections workforce, while the House bill reads just corrections workforce. So the only difference between the two bills is the word the.
So is that or just pass this clean and then let it go?
Yeah, if you pass it clean, and assuming that the House doesn't, I haven't talked with anybody in the House about whether they have an issue with the word the, but substantively the bills are identical. The program will be named based on whichever bill is signed by the governor last.
Here we go. I'm going to defer to Miles on this. And so Miles, this is going to be the biggest decision you make all day. Do we keep the?
Question. On page 4, lines 9 to 15, does that mean that a startup business cannot receive anything? And why not?
Page 4,
9.
lines 9 through 15. And let me just go back to the lead-in language. Department shall, so starting in subsection F, department shall administer the program and award startup and stabilization grants under the program on a competitive basis to a public safety agency or group of public safety agencies that meet the requirements of this section. And then,
Okay.
sorry, let me, in paragraph 2, that's the lead-in language I was looking for. Department may award. Oh, never mind.
It's just a union.
Yeah.
It's a,
Miles, I'll just defer to you, but I suspect this was language was part of negotiation with some of our folks in labor, and was a product of those discussions.
Yeah, correct. So that.
Right.
We just pass it clean.
So we're gonna pass this clean. Okay. Second. Is everyone okay with me recording the affirmative? All right, House Bill. I'm sorry, go ahead. Yeah, Senator West.
So I know how these things work. If we pass 2 virtually identical bills, is it correct the governor can sign both and the last bill he signs becomes the bill that's law? I had no idea. Interesting.
So we're now gonna go to House Bill 664.
House Bill 664 authorizes a certain protected individual or the Office of Information Privacy in the Administrative Office of the Courts to request that a governmental entity or person not publish personal information of the individual on the internet, social media, or social networks, or to remove the information from any existing publication. It also specifies certain procedures for the protection of personal information of a protected individual. And it authorizes certain relief for a violation of the act. This bill is identical to the Senate version, which passed 10-1 in this committee and 43-1 in the Senate.
It's, so just second. Do we do the same vote as before? All right, record the same vote as before. Yeah. All right, House Bill 732.
House Bill 732 repeals the prohibition on an ordinance of Baltimore City or an act of any municipal officer from conflicting, impeding, obstructing, hindering, or interfering with the powers of the Baltimore City Police Commissioner. The bill takes effect June 1st, 2024. This bill is different than the Senate cross-file Senate Bill 894, which passed the Senate 45-0. The Senate version included a provision making the bill contingent on the passage of an amendment to the charter of the city, providing for the appointment, terms of office, and powers and duties of the Baltimore City Police Commissioner, and the powers and duties of the Baltimore City Police Department, and also its ratification by the voters of the city at the 2024 general election.
Senator from Baltimore City made a motion to conform. Second, is everyone okay with that? All right, now the bill's before you is amended. Motions for favorable. Second, all right. Everyone's sorry. House Bill 732 passes with amendment unanimously. We'll now go on to House Bill 801.
House Bill 801 makes various changes to procedures related to the release of a person committed to the Maryland Department of Health after being found not criminally responsible or NCR. The bill establishes that the Maryland rules governing discovery and circuit court cases apply to a proceeding to determine eligibility for conditional release or discharge, requires a court and MDH to promptly inform a committed person's counsel of record when they receive a report that a committed person violated a condition of release or violated conditional release respectively, requires a court on request of any party to hold a hearing after an application is made for a change in the conditional release of a committed person to determine whether the applicant has satisfied the requirements for release. And it establishes that a preponderance of the evidence standard applies to an applicant in change of conditional release proceedings. Finally, clarifies that a court may extend a conditional release by up to 5 years and authorizes a court to shorten or terminate a conditional release. There is a Senate cross-file, which is Senate Bill 551, which passed the Senate 45-0. The Senate version is different. Unlike the Senate version, the House version contains a provision specifically requiring that on the request of a state's attorney, the committed person or counsel of record for the committed person, the health department would be required to provide reports, assessments, evaluations, and similar documents concerning the committed person. There's also a technical difference between the two bills, and it's really non-substantive. The only substantive aspect is the disclosure of reports language.
Seems to make sense. Right here. Okay, we're gonna hold it just for,
Yes, please. So, yeah, we want the health.
yeah, I like it too better. All right, so the motions for favorable. Is everyone okay being recording the affirmative? All right. House Bill 801 passes unanimously. We'll now move on to House Bill 832.
House Bill 832 defines damages or losses and statutory causes of action to protect civil rights or consumer rights, and provides that damages or losses includes reasonable nominal damages. This bill is substantively identical to Senate Bill 839, which passed the Senate unanimously. However, the Senate version had a preamble, and so if the committee wishes to add the preamble to this bill, then
It should have been, no, they didn't, he forgot to put it in. It should have been in.
Move favorable on the House.
No. Come on, Chris. I'd like it to be, I'd like it to be amended to the Senate version.
I can
It gives the
read it off.
history as to why the bill was put forward.
Move favorable on the House bill.
Ooh, we got a second on, signal orders, so we'll run it. It just means the preamble that gives you the.
Right.
It's very long.
I don't think you want to read it. I said we already voted for it, so. Oh, you want to?
Senator McKay, do we need a roll call? Or are you okay? Senator West?
So we're conforming, this is an amendment.
No. We're conform, the motion's to conform, so.
Right.
Yeah,
To conform, this is, okay.
Yeah.
Okay, thank you.
all right, everyone's okay being recorded in the affirmative. House Bill 832 with amendment passes unanimously. We'll now move on to House Bill 973.
House Bill 973 requires the Maryland Police Training and Standards Commission to develop a uniform citizen positive community feedback process to be adopted and followed by each law enforcement agency. The process must be simple and posted on MPTSC's website and on the website of each law enforcement agency that maintains a website. Each law enforcement agency must maintain a record of positive community feedback for all law enforcement officers within the agency. A record of positive community feedback that was not solicited by the police officer who is the subject of the feedback is not considered a personnel record under the Maryland Public Information Act. Notwithstanding any other provision of law, records of positive community feedback are subject to public inspection in accordance with PIA. The Senate cross-file, which is Senate Bill 7, passed the Senate 45-1. However, unlike the Senate bill, the House bill includes a provision that the positive feedback have not been solicited from the police officer. How do you know if it was solicited?
All right, motion to conform to the Senate.
Correct.
Is everyone okay with that?
Yes.
All right, now the bills before you is amended, motions for a favorable with amendment. Evans gave recorded in the affirmative. All right, House Bill 973 with amendment passes unanimously. We'll now move on to House Bill 1037.
House Bill 1037 establishes the task force on the creation of a division of returning citizens and expanded reentry services. This is the cross-file to Senate Bill 1036, which passed unanimously. There is one very minor difference between the bills. So on page 3 of the House bill, in lines 19 and 20, this is the standard language that the committee has been adding to task forces. The House version says at the first meeting of the task force shall vote to adopt a code of conduct. The Senate bill says at the first meeting of the task force that occurs on or after June 1, 2024, which is the effective date of the bill. That's the only difference between the two bills. Of the task force, so.
Yes, House Bill 1037 passes unanimously with amendment. All right, House Bill 1081.
House Bill 1081 establishes that automatic license plate readers' historical data captured in accordance with the existing law is the property of the law enforcement agency and may not be sold for any purpose by a law enforcement agency or a vendor contracted by a law enforcement agency. This is the cross file to Senate Bill 840, which has passed the Senate. There are a couple of differences between the bills. So first of all, the House bill, the amendments which were done for both bills are substantively similar, but the House amendments, I think, were drafted slightly differently and possibly a little bit more clearer. And then the Senate bill had a floor amendment attached to it, which required law enforcement to report on the number of license plates that are obscured and unable to be read by these license plate readers. The House bill does not have that additional provision.
We want to move this House bill in conversations with the state police. Is my understanding that the Kagan amendment is not, they're not able to deal with it. So the preference is to pass HB 1081 and have them, I think over in the House, they're gonna make modifications to the Senate bill.
Yeah, I just want to support that amendment. And I had similar discussions and nothing takes away from what Senator Kagan is trying to do. She's well intended and we have to do that in some way. It just doesn't work technically with how license plate readers operate. And so, so I support Senator Sidnor in his amendment.
All right, it's just, wait, not his amendment, but just the motion.
His motion.
Yeah, sorry, just make sure. So the motions were favorable, no, is that okay? Being recorded in the affirmative, okay. House Bill 1081 passes unanimously. All right, we're gonna go over to voting list number 20. I want to just House Bill 20. House Bill 761. That's Josh. 20.
House Bill 761 requires that fines collected by Montgomery County as a result of violations enforced by school bus monitoring cameras on state highways be remitted to the comptroller for distribution to SHA to be used solely to assist in covering the cost of roadway and pedestrian safety improvements at locations in Montgomery County along state highways where students board or exit a school bus or travel to or from a destination at which they board or exit the school bus. There is an amendment in your packet. It's number 213324/1. This amendment adds to the bill a prohibition that beginning on December 1st, 2025, a school bus stop in Montgomery County may not be located on a highway with 5 or more undivided lanes unless there is a crossing guard or a traffic signal that displays red at the time the bus is stopped and picking up or dropping off at this stop.
And so I'd like to move the amendment. Now the bill's before you as amended. Motions were favorable. All right, we got it open. Got it.
There's no cross file on this, right?
All right, House Bill 761 with the amendment passes unanimously. We're now going to go on to one last consent calendar. We're gonna go jump back over to voting list 21. It's a consent calendar.
House EPM and HGO.
These are
bills.
HGO and ECM bills. I had discussions with both chairs. They're moving our material as well. The motion would be for a favorable.
For all of everything.
Yeah, these are all bills that pass unanimously out of JPR. All right. Second, is everyone okay being recorded in the affirmative? We're on House Bill. We're on the vote. We're on voting list for 21. It's a consent calendar. All right.
Yes, I apologize.
Just to be clear, is everyone okay? Yes. Just want to make sure everyone's all right. Excellent. All right, so the consent calendar passes unanimously. All right. All right, see you all on the floor. We're gonna come back for a short voting session. Depends on how long the floor is today. That's the problem. So let me stand by for the floor. Stand by. Yes, we have excellent. Yeah. We have 3 work groups that are going to be engaged after this floor as well on the housing bills. So got a lot of work. Okay. Yeah.